people to kill her, 2 people to cover up her murder, 1 person who I think the evidence is clearly established was the one who actually dumped her like trash. And like I said, Brittany will have her day, but today, it's this defendant's day. Ladies and gentlemen, I am going to sit down. Mr. Greenwald will have an opportunity to talk to you. It's important that you understand the concepts of the law. The judge will also give you. Please remember, truth is right before your eyes. And I'll be back.
Mr. Greenwald.
Thank you, Judge. Good afternoon, ladies and gentlemen. Hopefully you can hear me okay. Good news and bad news. The bad news is each side gets up to 2 hours to talk to you all. The good news is I don't plan on taking 2 hours to convey from our perspective what should be conveyed to you all. Now, we're blessed here in Gwinnett County. Ms. Nizam, Mr. Brown, excellent, fine prosecutors. Should be very proud to have them working in the district attorney's office. They do a great job. Judge Duncan does a great job. Every time I'm before her, she is sort of the referee in this case. We rise, if you want to know why the lawyers rise, when you all come in the courtroom, it's a sign of respect. Because you all are the actual judges in this case. You are the judges of the facts as you find them to be. After I sit down and Ms. Nizam gets to come back up and make a concluding argument, Judge Duncan will tell you what the law is, define legal terms for you, and it's called jury instructions, jury charge. And then after the judge tells you what the law is, you'll disappear back through that door and you will get a chance to deliberate and return a verdict that, in your opinion, speaks the truth in this case. It doesn't matter. It's a hard thing for a lawyer to say, but it doesn't matter what the lawyers think. It doesn't matter what the lawyers believe. What matters is the evidence in this case. And what matters is what you all ultimately believe and ultimately decide. Now, as I told you in opening a couple of days ago, I'm not a moron. I'm not an idiot. I get the heartstrings of this case. I've got 3 kids at home. My late dad was a New York police detective for 30 years. So I get it. It's tough. It is awful that all of us had to meet under these circumstances. It's a tragedy. Can't shirk it, can't put it aside. It's awful. But one of the charges that Judge Duncan is going to tell you is sympathy has no place in your verdict. All of you are sitting in those comfortable chairs rather than out there on the benches because you all told us in jury selection that you were impartial. You heard it over and over again. Were you leaning towards one side versus the other, or were you right down the middle? All of you said you were right down the middle. That's why you're sitting there now. And so when you go back to deliberate, and yeah, it's an awful case. It's a horrible case. It's not a shoplifting, it's not drugs, it's not DUI. I get that. But you're to base your verdict or the lack thereof, not on emotion. And so, Ms. Nizam, in her first closing argument, she used the phrase, and she's an excellent lawyer, I'm not knocking her. She used the phrase, little Amari. Amari's broken little body. Those are all emotional terms. Those all tug at the heartstrings. And the case itself tugs at your heartstrings. I get that. But at the end of the day, ladies and gentlemen, after I sit down, Ms. Nizam sits down, Judge Duncan tells you what the law is, you are to base your verdict in all these counts not on the heartstrings, not on emotion, not on sympathy. You are to base your verdict on the evidence or the lack thereof. Plain and simple. No matter what phrases you hear, no matter the images that are posed to you, whatever words are used, that's what you're to base your verdict on. The evidence or the lack thereof. So, start off with this concept. There is no direct evidence, and there's two types of evidence: direct evidence and circumstantial evidence. So let's talk about what's direct evidence. Direct evidence is witness comes in, says, I saw Celeste kill Amari. Saw her hands around her neck, saw her take a hammer and hit her. That would have been direct evidence. Somebody actually saw it. You don't have that in this case. Yeah, you saw the videos up on the screen of what was going on in the Congress Hotel. That was in July of 2021. That was not November of 2021. You saw no videos from the room at Hometown from November. So those videos that were played with Ms. Hall in some and Ms. Owens purportedly in the other were from July of 2021. So first off, in regards to malice murder, felony murder, the other two counts of felony murder, ag assault, ag battery, and you'll have the indictment out with you. There's no direct evidence that Ms. Owens, and you may hear her referred to as a defendant, well, she's Celeste Owens. There's no direct evidence she killed Amari. That's the starting point. Obviously, they're sitting at that table representing the state of Georgia, prosecuting the case, so that's their view of the evidence. But the evidence in and of itself, there is no direct evidence that she killed Amari. So you get to circumstantial evidence. And Ms. Nizam gave a very good description of what is circumstantial evidence. You go to bed, you're in your bed at night, and you hear droplets coming down on the roof, lightning, thunder. You believe it's raining. You wake up in the morning, go outside, the sun is out, the pavement is dry, the grass somewhat wet. Well, circumstantial evidence, it might be that it was raining the night before. But pavement being dry, it could also be asserted that that's morning dew. The sun is out, there's no puddles on the ground, yet the grass is somewhat wet. That is circumstantial evidence, because you didn't actually see what caused the ground to be wet after the sun came up the next morning. So that's the two types of evidence: direct evidence or circumstantial evidence. There's no direct evidence she killed Amari. I would submit to you all there's also no circumstantial evidence Celeste Owens killed Amari. Now, you got the videos, you got the photos, but that doesn't prove what took place in November. Now, I'm also not an idiot and not a moron standing up here before you all. I'm not telling you you have to like Celeste Owens. I'm not telling you you have to appreciate her, respect her, like her. I'm not telling you that at all. But this case is not about who you like, who you don't like, who you respect, or who you don't respect. This case is about the evidence. When the state brings these charges, I don't care if it's 1, 2, or 22, they do have the burden of proof by evidence, beyond a reasonable doubt, that the person or persons, and in this case they've charged 2 people, Mom, Brittany, and I'm glad to hear she'll have her day in court, probably sometime in the new year, and my client, Ms. Owens. She's the one who's been on trial this week. So the state has the burden of proving to you all, beyond a reasonable doubt, that she is guilty of these crimes. Not that she's a bad person. Not that you should hate her, dislike her. The burden of proof, this is a criminal case, the burden of proof is by evidence to convince you all that she's guilty of all of these charges, by direct or circumstantial evidence. They further, when you have the indictment out with you, you will see in each count, other than count 21, in each count, and I think count 20 deals with Brittany lying to the police, saying her daughter went missing. So counts 1 through 19, you will have, and you'll see the way it's indicted. And indicted just means charged. Fancy legal word for charge. You'll see that they're indicted individually as well as parties to the crime. What does that mean? That means the state is trying to have it both ways in the indictment. You'll actually see those words in the indictment, individually and as parties. The way it says, just to give you an example, in regards to count 1, it says, grand jurors charge and accuse Brittany Nicole Hall and Celeste Alexandria Owens individually and as parties concerned in the commission of a crime with the offense of malice murder. And it goes on that way for the next 18 counts. Individually, that they each individually killed Amari. And or parties together, working together by assisting each other, helping each other, committing these crimes. Well, which is it? Doesn't matter in regards to the evidence, because the evidence, whether direct, is not there, and whether circumstantial is not there. Not only that Celeste did not individually kill Amari with malice or without, but the evidence is simply not there that she assisted, helped, participated with Brittany in killing Amari. That's a tragedy. It absolutely is a tragedy. We should not be here, but we are. And since we are, when you go back out there after listening to Ms. Nizam's, I'm sure it'll be a great closing, and the instructions from Judge Duncan, when you go back out there to deliberate, this is not whether she's a good person, whether she's a nice person. This This is whether or not the state, by evidence, has proven her guilt, either as individual or as a party to the crime in killing Amari. Party to a crime in basic terms means doing something, helping, assisting, participating. And in going over all the evidence, the videos, I just heard Ms. Nizam say something about 2 voices on those videos. It's not a crime to talk. It's not a crime to speak. Party to the crime means doing something to help the person commit the crime. Classic example is the liquor store robbery, where one person's the driver. They drive up to the liquor store, the gunman gets out of the car, goes into the liquor store, holds it up, gets the cash, comes back out, gets back in the car, and the getaway driver drives them both away. That's a party to a crime. The getaway driver, aware of what his co-defendant, armed robber, is doing, is the getaway driver. That's a party to the crime. Ask yourselves, in regards to the evidence in this case, what specifically did Celeste Owens do to help, assist, participate with Brittany Hall in killing Amari? What did she do? We don't even know, evidence-wise, ladies and gentlemen, the day Amari died. More importantly, we don't even know, evidence-wise, I don't care what lawyers say, evidence-wise, where Amari died. You don't even have any evidence of that in this case. So they want to say that Celeste, individually or as a party to the crime with Brittany, killed Amari, helped Brittany, assisted Brittany in killing Amari. Let's start off with, where was she killed? We don't know. We have no evidence of that whatsoever. And so from an evidence standpoint, I submit to you all, there is no evidence, not opinion, not talk, but evidence of what Celeste Owens actually did to help, assist, participate in Amari's death, Amari's killing. You don't have that. State has their theory, of course, and that's why we're here with these charges. But bringing charges does not mean somebody is guilty. The videos from July, yeah, horrific. Absolutely. But it's not evidence of what took place purportedly in November. It's not evidence that Celeste Owens knowingly assisted or participated in November in killing Amari. But they're hanging their hat, they're banking on what took place via video in July. It was Brittany who was Amari's primary caregiver. It's not a co-parenting relationship. We heard that from grandmother, Ms. Wright, that she and Brittany would co-parent all 3 children. And in that house, in that motel room, when the police showed up, who was giving the majority of the info? Height, weight, autism, medications to the police about Amari. It was not Ms. Owens, it was Brittany Hall, the mom. So she was the primary caregiver for Amari. I submit to you all that fact is uncontroverted. You heard from Zaire. God bless her. 9, 10 years of age, having to come into a courtroom in front of a group of strangers. Thankfully, she had a good rapport with Mr. Brown, with Brian. thankfully, he told her that a nice man was going to be asking her some questions after he sat down. And I appreciate him telling her that. And I submit to you, she's a child doing the best she could. What's important, though, that I ask you to remember is Zaire, she didn't remember her mom's name. Okay. And she's up there doing the best she can. But she told you all, Mommy never hit me. Brittany never hit her. That's just not true. Ms. Wright, God bless her grandma, she was unaware that her daughter was using corporal punishment, hitting, smacking, kicking, stomping on her own children, Ms. Wright's grandchildren. But it's just not credible, not believable for Zaire to tell you all that Mommy never hit her, because that's not true. She also testified, and remember Judge Duncan swearing every witness in to tell the truth. I'm not knocking Zaire, but these are factors that you all have to take into consideration in deciding this case. Zaire testified she never slept in a bed. May seem like an innocuous response to something, but it's important. Why? Because for almost 3 months, from September through November of 2021, they slept in that second bed, in that room there at the hometown suites. When police came in that motel room to talk to Brittany and Celeste, what did they say? 2 other kids, who would include Zaire, were asleep in the bed. That's important because Zaire told you all she never slept in a bed. That's just not true. She told the police when Mr. Brown sat down and I got to ask her some questions, she had seen her interview and it refreshed her recollection when she had talked to police 3 years ago. And I asked her, you remember telling the police that it was a man who took Amari by the neck and put her in a dark room? She said yes. She remembered that because that's what she told the police, that a man took her sister by the neck and put her in a dark room. She said also to the police, Amari had toilet paper in her mouth, and the next morning she wouldn't wake up. That's what she remembered from November of 2021. But none of that, ladies and gentlemen, from an evidence standpoint, shows Celeste Owens killing, murdering with malice or without Amari. None of that does. Ms. Wright was unaware of Amari's autism and was unaware of her medications. And I applaud Ms. Wright for being a great grandmother. I mean, she took care of these kids as Brittany came in and out of her life. Would have one child, go back to the nest, leave, have another child, go back to the nest, leave, and have another child. And God bless Ms. Wright for stepping into the breach time and time again in an incredibly painful situation. But none of that shines any evidence on Celeste Owens being a killer. I'm going to leave the cruelty to children counts. If you can square away and figure out the tattoos on the legs, no tattoos on the legs, who's doing what to whom back in July of 2021, I will leave that up to you all to decide from an evidence standpoint. But in regards to counts 1 through 8, the murder, malice murder, felony murder, battery for the lacerated liver, aggravated assault on Amari with an unknown object, please ask yourselves, no matter what I say, no matter what Ms. Nizam says, evidence-wise, where is the evidence to prove beyond a reasonable doubt that Celeste Owens did those things? It is not there. You'll have the verdict form out with you. That will go out with items of evidence. The verdict form lists all the counts, and you are to make an independent decision as to each count. Whatever your verdict is, you take count 1, count 2, count 3, and so forth. And let me go over, ladies and gentlemen, a little bit about what I expect Judge Duncan to tell you is the law in this case. Judge Duncan, I expect, will tell you that the defendant, Celeste Owens, is presumed innocent. So when we started the trial, it really wasn't leaning this way, it was leaning this way. Because Judge Duncan will tell you that the presumption of innocence surrounds and protects Celeste, and that presumption remains with her, innocence, until it is overcome by the state with, not opinion, you'll hear the word with evidence that is sufficient to convince you all beyond a reasonable doubt that she is guilty, and that the state has the burden of proving each and every element of each crime charge beyond a reasonable doubt. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. That's what a reasonable doubt is. Judge Duncan will tell you that the burden of proof rests upon the state to prove it beyond a reasonable doubt. She will tell you there is no burden whatsoever on us. We don't have to do anything. I could have sat here all trial, not asked one question, not done anything. Didn't have to make an opening statement, didn't have to make a closing statement, because there is no burden whatsoever on the defense to do anything. Still America, 2024, we don't have to do anything. But I did ask questions. Judge Duncan will also tell you that if the state, the prosecution, fails to prove Celeste Owens' guilt beyond a reasonable doubt, it would be your, and this is a key word you will hear when the judge tells you what the jury instructions are, it would be your duty to acquit her, find her not guilty, if they fail to prove her guilt beyond a reasonable doubt. You will hear that grave suspicion, mere conjecture, suspicion, maybe, could be, possibly, she's guilty, are not sufficient, aren't enough to find her guilty. Suspicion, conjecture, is not what the law requires. Yeah, the law doesn't require 100% mathematical certainty. That's absolutely correct. But the law does require proof beyond a reasonable doubt. And suspicion and conjecture, speculation, are not sufficient for you all to find her guilty. Judge Duncan will tell you that Celeste was under no duty, under no burden to testify. She didn't have to get up here and say anything. Because just like I didn't have to do anything, or say anything, or ask any questions, there is no burden on Celeste whatsoever to have to testify. And that you cannot, when you go back and deliberate and go over the evidence and the judge's instructions that you hear from her, you cannot use that in your deliberations, the fact that Celeste Owens did not choose to testify. Cannot at all base your verdict upon that. Judge Duncan, ladies and gentlemen, will define for you what parties to a crime is, because when you have the indictment and you look at it, you will see it says individually and as parties to the various allegations. And a party to a crime is a party to a crime only if, and you will hear Judge Duncan tell you that, only if that person, in this case, Celeste Owens, only if she directly commits the crime or intentionally helps in the commission of the crime. That's it. To be a party to a crime, you either do it directly or you help someone participate with that person intentionally in committing the crime. You don't have that in this case, ladies and gentlemen. There is no evidence for either of those, that she directly killed Amari or intentionally helped Brittany kill Amari. Knowledge is an important aspect of party to a crime. And the judge will tell you, if you find from the evidence that the defendant, again, Celeste Owens, did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense or offenses. You're going to hear those words again, those two words. It would be your duty to acquit the defendant, Celeste Owens. Find her not guilty. Judge Duncan will define for you what mere association is. It's the old adage, who you hang around with. If you hang around with the kids, I was always told, if you hang around with the kids from the other side of the tracks, you're going to get in trouble. So don't hang out with them. But mere association is not sufficient. Who you hang out with, who you choose to be your girlfriend, your partner, spouse, that's not sufficient. Judge will tell you a jury is not authorized, you all, to find a person who was merely associated with other persons, Brittany, involved in the commission of a crime, guilty. Just who you choose to hang out with, just who you choose to be with, just who you choose to be in love with, associate with, is not enough. They, again, have to show you did something or helped in doing something in order to be guilty beyond a reasonable doubt. Malice murder, count one, essentially with malice aforethought, those legal words that Ms. Nazan was talking about. Malice, bottom line, is the unlawful intention to kill. You unlawfully intended to kill Amari. That's what count one must be proven by the state by evidence beyond a reasonable doubt. It is not there that she unlawfully intended to kill Amari. The murder counts, felony murder counts. You have battered, ag assault, cruelty to children, all dealing with November. Not talking about July here, we're talking about November. And the state, beyond a reasonable doubt, must prove that Celeste caused the death of another person, Amari, by committing a felony, either ag battery or ag assault or cruelty to children. Again, they don't have to show malice, but what they do have to show is this person sitting over there who's been sitting next to me for 5 days, by evidence, killed Amari during a felony, or participated or assisted in Brittany killing Amari during the commission of a felony, by evidence. And ladies and gentlemen, they have not. And lastly, as I started off early on in my closing, ladies and gentlemen, Judge Duncan will tell you that your verdict should be a true verdict, based upon your opinion of the, it's not going to say opening or closing statements of the lawyers. It's not going to say which lawyer or lawyers you liked or didn't like. Your verdict should be a true verdict based upon your opinion of the evidence, according to the laws given you in this charge. Judge Duncan will further tell you, you are not to show favor or sympathy to one party or the other. Brutally tough in a case like this, where you have an 8-year-old who's gone, who'll never see another birthday or Christmas or graduation or grow up. Yeah, it's brutal. Absolutely it's brutal. But when you swore your oath, that's what you swore to do. You are not to show favor or sympathy to one party or the other. Judge Duncan will tell you it is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. Extremely tough and brutal in a case like this. But that's why you all were chosen, because that's what you swore an oath to do, and Judge Duncan will tell you that. She'll lastly tell you, ladies and gentlemen, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, economic status, for or against either party. Quite simply, you take people as you find them. You take the evidence as you find them. You take the law as given to you by Judge Duncan, that she will tell you after we sit down. I don't get to come back up here and counter or refute anything that Ms. Nizam or Mr. Brown, either one of them, comes back here and says in closing. Now, sitting over there, I may go, oh, I should have covered that. Why didn't I cover that? But at the end of the day, the bottom line, ladies and gentlemen, is the state has the full, total, and complete burden of proof beyond a reasonable doubt to prove to you by evidence that Celeste Owens is guilty. And I submit to you, in regards to the particular case before you all, the evidence that's been presented, that's not been presented, you never heard squat, jack about the crime lab. So none of those pillowcases, clothing, none of that stuff was ever sent off. Or if it was, never got any results back. Because if there had been blood in any of that stuff, I submit to you, you would have heard about it. But you don't have any of that before you. So what you have in this case, ladies and gentlemen, is supposition, is guesswork, is, well, this is from July, let's equate it now over to November. Guilty. I submit to you, ladies and gentlemen, please hold the state to their burden of proof, as the judge will tell you you must do. Render a verdict that speaks the truth in this case based upon the evidence and the lack thereof. Follow the judge's instructions regarding your duty and ask you to return a verdict of not guilty. Thank you.
Thank you, Mr. Greenwald. All right, ladies and gentlemen of the jury, I want everybody to stand up and stretch for a moment. Everybody good? And be seated when you're ready.
To believe that this defendant did not directly commit, help, or participate in the death of Amari Hall is to believe that essentially the defendant was tasked with caring for these children, being called their dad, being in a relationship with Celeste, with say that she had been in a relationship and had been getting to know the kids and being with the kids for going on 2 years, and that while all this is happening, she's just standing there watching. Just standing there, not doing anything other than watching Brittany Hall beat Amari. That's what she wants you to believe, and that's simply unbelievable. And the evidence is clear as to why that's unbelievable. And let's look at it now. So let's look at these videos. You see them, and it's hard to unsee them. But they saw it every day. She saw it every day. And the reason these videos are important, the detective, Detective Sorensen, said that they occurred over a range between July 20th and August 9th of 2021. That's when they were stamped. And the judge will also tell you that the date really doesn't matter, as long as it happens before the filing of the indictment. So we can pick a date, which was the first day, July 20th of 2021, but those videos occurred over a period of time. Detective Sorensen told you that, and the judge's law will also tell you that that date is not going to be an issue. But it is important. And here's why. It's important because Dr. Downs said that this was a pattern of abuse that had occurred starting from anywhere between days to months, various stages of healing on all of these different injuries on Amari. So what happened at the Congress Hotel does matter. It matters a lot. And this defendant directly was abusing not just Amari, but all of the children. Call it luck that the detective found those videos. Call it divine intervention. I don't know what it was. But we do know that it happened. Ms. Penix came in here to tell you that the Congress Hotel, that's located here in Gwinnett County, because we have to prove to you that it occurred here in Gwinnett. So that's why she came in here to tell you that. And so these videos and the individuals on the videos, Sergeant Campbell, the reason he came in here and gave a big pamphlet of all the different tattoos that are found on both defendants is so you can decipher who is who on these videos and who is doing what to whom. Now remember, all the evidence that came in, you will have that with you. You will be able to take that back, the photographs, the charts, all the different things. You'll be able to look at that yourself. This is Celeste Owens. This tattoo, I submit to you, you will see several times on the videos. You will see her face on several of these videos. You will hear her voice, which you spent almost 2 hours listening to when she spoke to Detective Sorensen. And you'll know that she has no tattoos on her legs. So we know when there's a tattoo on the leg that it's going to be Brittany Hall. That's what Sergeant Campbell's purpose in coming to court to talk to you guys was about. And each of the counts in the bill of indictment, as they pertain to the cruelty to children charge, deal with the fact that we have to prove that this defendant, either individually, on her own, or as a party to a crime, either helping or being part of, remember, 2 people can commit the same crime, depending on the role that they play. Being there, having the same pattern of abuse, doing the same types of things, and being seen on video doing it, whether it was in July, August, or November, doesn't matter. Causing cruel and excessive physical and mental pain. So let's go straight to the point of what these videos were about. How humiliating.
Lace this shit, sweet your ass, bitch. What is it? He and all in front of the church. As soon as you walk out, he
To call an 8-year-old that, that's just sheer humiliation, right? Mental pain, excessive mental pain. Count 8 charges both defendants, but again, we're here for her today, for slapping Amari, causing her head to whip back while sitting on the ground. Here's count 8. Guilty. We have to prove that beyond a reasonable doubt.
Don't move.
The tattoo on the arm, the voice, this defendant. Blindfolded children laying on the ground covered in blankets. This is not discipline. This is torture. This is humiliation. This is savage. Count 10, stomping on Jakari while he's laying on the ground and telling him to go to the bathroom. Again, the language we have to prove beyond a reasonable doubt in count 10 of the indictment.
Let's go to the bathroom.
Guilty. And as an aside, remember Dr. Downs talking about Amari's lacerated liver? And how it could be caused by blunt force, flat surface like a foot hitting the floor, getting squeezed between the two? Count 11, kicking and stomping on Jakari while telling him to move over. No tattoos on those legs. The language of count 11.
Move over. Put your arm down. Put it down. Go.
Guilty. Again, same manner in which Dr. Downs testified Amari's injuries could have occurred. Count 12, striking Jakari repeatedly while he's sitting on the floor wrapped in a sheet. Again, look at Zaire. Blindfolded, staring at the wall with a sheet wrapped around her. She is 6 years old.
I know it's not for changing. Huh? He's gonna get smacked. First of all, he's gonna get smacked now. I don't know if he's looking at me. Hey, I'm gonna handle it. Stop looking. Do you understand me? Keep your eyes to yourself. Do you understand? Stop looking. Stop looking. I smacked earlier for that.
Guilty. Count 12. Count 13. There's that koi fish tattoo again. This defendant striking Jakari and stomping on him, just like Amari's lacerated liver, while laying on the ground, shirtless and blindfolded, telling him to go to sleep.
Go to sleep.
Another stump, just like what Dr. Downs said.
stupid as fuck.
Because it's not enough to stomp on him, you've got to call him stupid as fuck, too, pardon my language. Same type of stomping. Doesn't matter who pulled the trigger, doesn't matter who stomped on that liver that killed Amari eventually. Count 16, slapping Jakari multiple times while he was standing.
Right now. Yes, man. Stop moving. Corner.
Guilty. Doesn't matter who's doing the slapping. Count 17, striking Zaire with an unknown object while she's laying on the floor. I do want you to pay close attention to the second voice.
You heard me? I'm standing right here. You got this. I'm standing right there. Hey, get the point.
Talk about helping. You got this. I'm standing right here. Does that voice sound familiar? Guilty. Count 18, stomping and kicking Zaire while she's on the floor and telling her to move the other way.
Turn the other way.
Guilty. Count 18. Why? Why would That's why. She didn't need the sheet. She didn't cover up Jakari. She just didn't want Zaire to have them. And why this?
Fuck your food. Turn around and put your hands up. I said swallow the food first, then take another bite because she's dropping mashed potatoes everywhere. And try to scoop it off the carpet with a spoon. Then I said stop. She stopped and I'm trying to keep going after I said stop. So I'll slap her stupid ass. Oh. Tomato busted in my mouth and almost got on my face.
You can see her face there in the corner. You can hear her voice. Who else is she talking to? There's only two people, two adults who lived in that room. Helping, encouraging, directly participating. Turn around and put your hands up. Stare at the wall. She's 6 years old. Guilty of every single count of cruelty to children in this indictment that this defendant is charged with. So let's move on to what really matters. It all matters because it's all connected. It's all intertwined. The first count in count 2 of felony murder has what we call an underlying count of cruelty to children. The felony in the felony murder in count 2 is cruelty to children. For causing Amari, who is under 18, cruel and excessive physical and mental pain by causing multiple blunt force injuries to Amari. 11 pages of injuries. Weaken her body. Various stages of healing. Various different places on the body. Those 15 videos show us that they act together. They encourage each other. They help each other. They hurt these children in the she just stood there and didn't do a damn thing is unbelievable. They're acting together. Amari is in the care of this defendant. She tells Detective Sorensen, yeah, we're there all the time, we're homebodies. The hours leading up to Amari, we know from Investigator Wilbanks that this defendant was in the hometown studios. We know that the only time she left, and we contend that this happened on November 19th, because that's why the U-Haul was rented on November 19th. That's why she drove to the area where Amari was dumped. That's why we know it happened on November 19th. How long could she keep a dead child at the hometown studios? By causing blunt force injuries to Amari, by committing the offense of cruelty to children, she is guilty of felony murder in count 2. She is guilty for causing the death of Amari through committing the act of cruelty to children. Guilty to count 2. Felony murder in count 3 deals with a charge called aggravated battery. There's a lot of charges because a lot of things happen to this little girl. And she commits the offense, and this is the language that you'll find that we have to prove to you, that she commits the offense of aggravated battery by maliciously causing bodily harm to Amari Hall by rendering a member of her body useless, specifically her liver. Now, useless is sort of a legal term. Obviously, when you sever or when you actually lacerate the liver, as Dr. Downs testified, it's no longer usable. In this case, it caused her death. It was one of the things that ultimately caused her death, not the only thing. In other words, the defendant's actions caused Amari to have a lacerated liver, which then ultimately, in relation to all the other things, caused her death. The stomping that you saw in the video, that likely caused it. That is the state's theory, based on what Dr. Downs had said. But again, put together with all the other injuries on that little girl, because that's what she was, a little girl. And it doesn't matter who inflicted it, because her actions, as you saw, helped cause the injury. And if you believe that she could have stopped on that child, hit that child, if you believe she could have lifted her hand to strike that child, based on everything that you now know, that she is a party to the crime, and she is guilty of felony murder by committing the offense of aggravated battery, that she helped, either directly or helped or encouraged that liver to be lacerated. She's guilty. She can be guilty of every single count. Remember, you don't have to pick and choose. Count 4, felony murder for aggravated assault. Aggravated assault is when you assault another person with an object, device, or instrument which you can use offensively against another person, and that it actually does cause injury or could cause injury. Again, lots of legal words for basically saying if you use something that could kill or seriously injure someone else, that is what's called an offensive instrument, an offensive object. And here in the indictment, the state alleges that we don't know exactly what it was. We don't know if it was a foot, we don't know if it was a hand, we don't know if it was a belt, we don't know what it was, because they were beating these children with hands, feet, some sort of whip type thing. And so we don't have to be able to show you exactly what that was. We can say that that object can be unknown, but it is likely that then she is guilty of felony murder for the underlying offense of aggravated assault. Essentially, she is guilty of all the murders charged in the indictment. It is one death committed in multiple ways. And that's why there are numerous charges dealing with murder. And you can find her guilty of each of those ways of committing murder because, as Dr. Down said, there was a lot of things that were done to Amari that caused her death, that she either helped with, encouraged, or directly participated in. So what happened to Amari on November 19, 2021? She certainly didn't look like that. Miss Wright told you this was taken in Miss Wright's house. The way Miss Wright always will remember Amari. Something happened, and it was likely an extension of all the things we've already seen and known. Maybe there was more beatings, maybe there was more blindfolding, more staring at the wall. Maybe it went too far. Maybe her little body, because it was little, couldn't take it anymore. The timeline, you will have all of this information with you. We've talked about it, you've heard the evidence, and you will have the information with you to go through. But what is very, very interesting, once again, is that in the search of this defendant's phone, all of these concerning searches that she did were deleted. Why? You don't want anybody to know that you're looking up how sewage drains work or how to find missing people. You don't want anybody to know that you're about to rent a U-Haul. Why? On November 19th, around 4 in the morning, something likely happened, whether it was a beating gone too far, that this defendant either directly committed, encouraged, participated in. Something happened, and that's why these searches on her phone, not Brittany Hall's phone, but her phone, began. Interesting searches, too. Why do you need to find a lake near her? Why do you need help finding missing people? Are you trying to dispose of a body? The state will submit to you that that's what happened. Amari is likely now dead, killed at the hands of this defendant. Now they've got to get rid of her. She's got to get rid of her. So she's got to figure out, well, what can I do? I don't have a car. I don't have any friends. I don't have any family, according to her. What can I do? Well, I better figure something out. I'll go and search up some great idea. And the searches begin. So she has to delete them in case anybody ever finds them, because they don't look good. Her movements are very telling. And again, you'll have the information. Detective Wilbanks did a fantastic job putting together all of her movements with the known information that we have. We know that on November 19th of 2021, this is why the state contends that Amari was killed on November 19th, because at some point early that morning before those searches started or around the time they started, and again, it doesn't matter what date it happened. We don't have to prove that, but the evidence shows that it's likely it happened on November 19th. Something happened, and Amari is dead, and the searches began. And ultimately, the searches for U-Haul take her to the nearest U-Haul at around 1 o'clock. And you know from the surveillance video, where she is clearly seen, you know from the contract that she's put all her information on, you know from Detective Blackburn telling you that he sees the name of Celeste Owens on the caller ID of the U-Haul that she's calling, or someone's calling from that phone. Obviously, it's got to be her. It's her phone. And you know from the photographs that are taken when the van is returned later that day, found on her phone, of her own driver's license, as well as the pictures of the U-Haul that is returned with the odometer, like you would do when you return a vehicle to make sure the tank is full or whatever you need to show. You see her leaving with the van that she has now rented around 1 o'clock in the afternoon, 1:13. And she stops at Family Dollar. And how interesting that what this defendant buys on video and through the receipt shows up at the hometown studios and stays there until 5:50 when it gets dark. Why does a person who lives at the extended stay hotel without a car need to rent a U-Haul for 6 hours? Because this defendant is transporting Amari's dead body out of the room. That's why. And coincidentally, right around that same time, as Detective Wilbanks testified, that's when the preferences on the iPhone changed, where the location data is now turned off, so no one can track where she's going in a rented U-Haul for 6 hours on the day Amari is likely murdered. At 5:52, the video surveillance that you viewed with Detective Blackburn shows that the van is moved to a spot closer and backs in closer to room 251. At 5:52, around that time after backing in, the van leaves. I am now telling you the last moments of Amari leaving her home questioned by one of the most experienced defense attorneys in this jurisdiction. And for the first time in 3 years, she saw this woman. Had to be 20 feet away from her for the first time. That's one brave little girl. And what she tells you is that she ate bread. She tells you she looked at the wall, and we know she did. There were no toys, not in the search of the room, not when the officers got there, no books, no homeschooling. There's nothing going on. They were getting beat and staring at the wall and blindfolded when they weren't. Slept on the floor, no pillows. You saw it. And what she told you was that Amari was put into a container with a lid by this defendant and put into the trunk of a car taken to the hospital for bad kids. And that's corroborated by seeing the U-Haul. Why do you need to rent a U-Haul? They know they don't have a car. Zaire knew that. See, Amari's in a container being put in the back of a car in the trunk. That's corroborated by the fact that she had to rent a U-Haul to put Amari in the back to take her away. She says the man took Amari. Is that who she called Dad? It's a lot for her to come in here. So why did they even call the police? Because now they got to figure it out, right? They got to figure out what they're going to do. They have to call the police. They can't pretend Amari never existed because Papa and Gigi, Mrs. Wright and Mr. Wright, they weren't going to give up. They weren't going to stop looking for their grandchildren. They told you they drove around from place to place, from extended stay, from hotel, looking for their grandchildren. And they weren't going to stop. And they knew that. They knew the kids would probably ask about Amari. But they still waited 2 days so they could get their story straight until they called the police on the morning of the 21st. Because it gave them enough time for the search history around 3:43 on the 19th of how do I report someone missing and what to do when a loved one goes missing. They're trying to figure it out. They're trying to prepare. What am I going to tell the police? What do they want to know? And you can tell because in the interview with Detective Sorensen, when the defendants get real agitated there towards the end, because they keep asking her where Amari is, that's not what she was expecting. Based on her Google search, I submit to you, she was expecting, and this is what she said to them, this is how you go about things. You get info for the missing child that night, then you give a courtesy call, and then you take a statement. That's what she thought was going to happen based on her infinite knowledge from Google of how to report someone missing. And that's why she was getting agitated. She didn't think it'd be a big deal, I submit to you. In her initial statement to the police, well, Sergeant Forrester came in to tell you how calm everybody was. Nobody was erratic. And Jakari and Zaire were quiet the entire time, even amongst all of the commotion, all the police activity. Clearly they're in a bed then because the police are coming. You gonna blindfold your kids and put them on the ground when the police are at the door? No. You go to headquarters. She's still calm. She keeps saying, I'm not in custody. I'm free to leave. And she was. You could hear the detective say that to her. Because at that point, all they wanted to do was find Amari. That's the only thing that they want to. And then what she tells them is a bold-faced lie. She says, I didn't go anywhere November 19th. One of the many bold-faced lies, but she said, I didn't go anywhere November 19th of 2021, which we know is not true, based on all the movements we just talked about, based on the plot, based on the surveillance video, based on the geolocation data. There's so many lies. I take her toys away and talk to her. So Amari, this is what she tells the detective in her statement when she's disciplining her. It never got physical. She would not hit the children. These are the things to Detective Sorensen by saying that she was with Diamond Owens at a time that was relevant in their investigation. That's count 21. She's guilty of that. And then all of a sudden there's a drastic shift in her demeanor, as you saw, ending with "you're a piece of shit" to Detective Sorensen, based on the fact that now she realizes the gig's up. They're not just taking a statement like Google said they would and making a courtesy call. Now they're going to go through her phone. Now they've talked to her family. Now everything changes. She's not that worried about Amari through that entire conversation. She only gets emotional when she realizes the gig's about up. And the phone, first she's fine, because in her mind she's deleted all her history. She's deleted all the stuff that matters. Probably forgot about the videos that are still there. She knew she turned off her location information. And then when she realizes, okay, well, maybe they're not as dumb as I think they are, then all she wants is her phone back. I just want to get my phone and leave. I want to get my phone and leave. That's what she tells the detective in the interviews. Mr. Greenwald talked about no DNA. I want to touch on both things. You heard that there was a search of the U-Haul for any kind of odor of a cadaver. And I want to make it very, very clear that there are some very logical reasons as to why the cadaver dog, whose first search it was, or second search it was, would not have hit on any kind of odor. And because we do believe Amari was carried in the back of that U-Haul van. And she told you, Ms. Schwartz told you, that the length of time in the back plays a big factor, that she would have only been in there less than an hour in the back, maybe in a container, but clearly in garbage bags, because that's where she was found, wrapped in garbage bags. And you can see in the crime scene photo that you'll have with you, there's a bag of Glad garbage bags, and they say leak-proof and neutralizes odor. We know she bought some bleach. Maybe she cleaned it. She had the backpack. And the DNA? You're right, the DNA wasn't tested because there wasn't anything to show. The DNA would show who was in the room. We knew who was in the room. We knew it was all four of them. That's not going to tell us whether or not this defendant participated, helped, or directly committed blunt force injuries and lacerated liver to Amari. That's not this kind of case. So why? Why do this to these children? I don't know, maybe they're an interference to the relationship. Maybe she doesn't know what to do with the kids. Maybe Amari was wetting the bed. She didn't really care about the impact that this type of behavior had on the other kids. This wasn't discipline, this wasn't anger, this was control. This was torture. These kids weren't doing anything. You saw in these videos, they're sitting there quietly, they're getting beat. Nothing that causes or anything like this to happen to them. We don't need to prove motive, the judge would tell you. But there is no reason, which is what makes it so much worse. And this was intentional. I want to point out something that is very relevant. The reason that we put in the weight of this defendant and the weight of Brittany Hall is to show the discrepancy in size. Now, this defendant said she weighed 231 pounds at the time. You saw the video. Sergeant Campbell said that's based on the honor system. Even at its best case scenario, she really was only 231 pounds. Amari was 54. And Zaire and Jakari were likely less than that. That kind of force, that kind of weight on top of those children, and Amari was already weak. That's why they were kept out of school. They had no friends. Those children sat there staring at the wall and having no idea that their Gigi and their Papa were out there looking for them. They had no idea the world was happening around them while they sat in that hellhole with her. You saw the injuries on Zaire the night that the police brought them to headquarters. Look at her little extended belly. defensive wounds that Amari had on her arms. That's Jakari, his back, his hand, his extended belly. Randy Work said that in his experience with special victims, that's usually associated with not getting enough food. And this was purposeful. It was purposeful because she deprived them of food. There was plenty of food in that little hotel room. She was eating it. So was Brittany Hall. There was food everywhere in that hotel room, except for Amari, Jakari, and Zahir. Battered child syndrome, based on Dr. Down's testimony, indicates there were so many different, multiple fractures that were caused over a period of time, different places throughout the body, weakened her body, along with the fact Amari's body, without having any food, she weighed less than the 5th percentile, no muscle development. Again, doesn't matter who caused the fatal blow, doesn't matter the blood force injuries, we talked about those, we talked about the binding on the legs. The legs, Amari's legs were bound. loved her hair, so they cut it off. Zaire said, Celeste cut it off. They didn't even put clothes on her. They didn't put her glasses on her. She loved to cook, so they starved her. When I say they, that's she. When I say she, it's they. They did this together. Doesn't matter. But today's her day. She treated her like trash. But Amari Hall was anything but trash. She was a little girl. A little girl who didn't have anywhere else to go in her mind. And she killed her. Ladies and gentlemen, the standards that we set for this community, the community that each of you have said you have chosen to live in, raise your children in, buy your homes in, work in. This community, the standards that are set in this community, what is acceptable and what is not acceptable in this community, it is not set by this honorable court or the district attorney's office or the Gwinnett County Police Department. It is set by all of you, each and every one of you, who in this moment in time will make one of the most important decisions that you will ever make within these hallowed halls of justice. Because today, the power shifts. This woman had the power over Amari for a long time, but today it shifts. It shifts here to you. The Gwinnett County Police Department knocked on every single door of the hometown studios looking for Amari. There is one door left, and that's this door. Right here. That leads into courtroom 204. That leads to you. Today is that day. She no longer has the power. This defendant is guilty of every single count, and I ask you to find her guilty on all counts. Thank you.
All right, ladies and gentlemen of the jury, is everybody good? You need a restroom break? Okay, all right, we're gonna take a 10-minute recess. We'll come back for the charge of the court. All right, anything to take up outside the presence of the jury?
Not for the state judge.
Mr. Greenwell?
You let him know, Judge, that, again, I know everything goes back with him, but obviously there's no mechanism for playing stuff out. Just so that they know there's nothing for playing any videos or anything.
Well, none of that goes back with them if they want to see any of that. So you want me to let them know that if they want to see a video or listen to anything again, they can ask?
Sure.
That's fine, Judge.
I will try to remember that. The court has provided you with the final charge of the court. Any exceptions
Just,
No.
other than already noted for the record?
is this the final?
This is the final.
No objection for the state judge.
All right, just take a 10-minute recess, thank you.
Thank you, Judge.
Hey. All,
No, we're gonna go through and see what needs to go out and what doesn't. Rob, you wanna come work with it?
And we'll put that on the record before it goes upstairs.
Yes, Judge.
I'll do that for you. Send it to me, Charlie. Can you bring it in?
Huh?
You want to do that before you bring it
I
in?
gotta wait for Miss Owens, so that's fine. We can do that. All right. With the defendant now present, what did you want me to explain to the jurors? Oh, about the videos.
Videos. That doesn't go back with it. They can watch it back in the court. What is it, the interview and then the surveillance cameras from you all and all that?
Yes, it's just surveillance cameras.
I know everybody.
Yes,
That's the,
yes.
so it's like her interview, judge, the surveillance from the store.
There's also a disc with the videos of the individual videos.
Right.
Ms. Nazam, Mr. Greenwald, would you guys like to go ahead and put on the record what is and what is not going back with the jury?
Sure.
The exhibits? Don't distract him.
I just literally.
Just give us,
He did it last time.
What is it?
and that's me.
Yes, that's
Go
yours.
ahead.
15 more
Sorry,
minutes.
sorry, it's a question.
It's all right, go ahead.
All right. This is, we don't, Judge, we can just go, it might be easier to put on the record what is not going back unless you would like everything on the record.
That's fine.
Okay, Judge, States Exhibit 100, 101, 112, 114, 116, 118, 20, 71, 21.
And those were for the record only, Judge.
Yes.
So what she's about to go into is in evidence, but if they want to see it, come back in court.
Understood.
Yes,
I just
Judge.
for record purposes.
And also for the record, States Exhibit 21 is a flash drive. And States Exhibits 27 through 41 are contained on one specific CD. States 119, 115, 26, and 102 are individual DVD discs. And then States Exhibit 26A is a flash drive. So those would not go back with the jury and everything else would. Is that correct, Mr. Greenwald?
Yes, except Brian and I put them in this pile so that if the jury wants to see or hear anything,
Got it.
you know, this,
Yes.
they can see this.
Maybe we can just put this over here,
Yeah.
just in case.
So, we're in agreement, Judge.
That's evidence purposes only, have that one separate, correct?
Yes, Judge.
Correct.
All right, it is noted for the record. Are you ready for the jurors?
State's ready, Judge.
Yes, sir.
All right, we have the jurors, please.
I was so close.
Sorry.
Be seated. All right, ladies and gentlemen of the jury, first let me say thank you all for your time and attention over the last week. It is very much appreciated by both parties and the court. What I'm now going to do is read to you what is called as the charge of the court, and that's basically where I go over the law that applies to this case. Ladies and gentlemen, you are considering the case of the state of Georgia versus Celeste Owens. The grand jury has indicted the defendant with the offenses of malice murder, felony murder, cruelty to children in the first degree, aggravated battery, aggravated assault, concealing the death of another, and making a false statement. The indictment states the exact offense or offenses which have been alleged by the state. You will recall that the indictment was read to you at the beginning of the trial, and it will be out with you as you deliberate. You are instructed to read it carefully and examine it for yourself. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations that have been approved by the court about facts and exhibits that are identified in documents titled Stipulations for Trial and Additional Stipulation for Trial that will be provided to you for your deliberations. Where the parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. When parties stipulate testimony, documents, and/or exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, Either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence, or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not a common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it properly entitled to receive. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence, for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his or her her constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had the right to remain silent. 2, if the defendant chose not to remain silent, anything she said could be used as evidence against the defendant in court. 3, the defendant had the right to consult a lawyer before any questioning and to have the lawyer present with her at all times during any questions. And 4, if the defendant did not have the money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching the verdict. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of the state in which there is a joint operation of an act or omission to act and intention or criminal negligence. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person A, directly commits the offense, B, intentionally helps in the commission of the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted. Knowledge on the part of the defendant that the crimes of malice murder, felony murder, cruelty to children in the first degree, aggravated battery, aggravated assault, concealing the death of another, and making a false statement were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find, beyond a reasonable doubt, that the defendant had knowledge that the crimes of malice murder, felony murder, cruelty to children in the first degree, aggravated battery, aggravated assault, concealing the death of another, and making a false statement were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that certain criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Gwinnett County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. The defendant is charged in count 1 of the indictment with the offense of malice murder. For malice murder, the state must prove that the defendant, 1, caused the death of another, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The defendant is charged in counts 2 through 4 of the indictment with the offenses of felony murder. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Cruelty to children in the first degree, aggravated battery, and aggravated assault are felonies, which I will define for you shortly. One second. You may find that the defendant is guilty of felony murder if you believe that she caused the death of another person by committing the felony of cruelty to children in the first degree in count 2, and or aggravated battery in count 3, and or aggravated assault in count 4, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must directly cause the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. The defendant is charged in counts 5 and counts 8 through 18 of the indictment with the offense of cruelty to children in the first degree. For cruelty to children in the first degree, the state must prove that the defendant, 1, maliciously caused, 2, cruel and excessive, 3, physical and mental pain, 4, to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice, in this context, means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. The defendant is charged in count 6 of the indictment with the offense of aggravated battery. For aggravated battery, the state must prove that the defendant, 1, maliciously caused bodily harm to another person, 2, by rendering a part of that person's body useless. In deciding whether or not the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. The defendant is charged in count 7 of the indictment with the offense of aggravated assault. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, and 2, with an object, device, or instrument, when used offensively against a person, is likely to or actually does result in serious bodily injury. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. An object, device, or instrument, when used offensively against a person that is likely to or actually does result in serious bodily injury, is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether an object, device, or instrument is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the manner in which an object, device, or instrument was used, and any other circumstance of the case. Although hands and feet are not deadly weapons per se, they may or may not be deadly weapons depending upon the manner in which they are used and the circumstances of the case. Whether hands and feet, if used, constitute weapons in this case are facts solely for your determination. The defendant is charged in count 19 of the indictment with the offense of concealing the death of another. For concealing the death of another, the state must prove that the defendant, 1, concealed the death of another, 2, which hindered the discovery of whether that person was unlawfully killed. The defendant is charged in count 21 of the indictment with the offense of making a false statement. For making a false statement, the state must prove that the defendant knowingly and willfully made a false statement in any manner within the jurisdiction of any department or agency of the government of any county. If, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did on or about November 19, 2021, commit the offense of malice murder, felony murder, cruelty to children in the first degree as to count 5, aggravated battery, aggravated assault, and or concealing the death of another as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County did on or about July 20th of 2021 commit the offense of cruelty to children in the first degree as to counts 8 through 18, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe, beyond a reasonable doubt, that the defendant in Gwinnett County, Georgia, did on or about November 21st, 2021, commit the offense of making a false statement as to count 21, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of any of these offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. I have prepared a verdict form for your use that will provide you with the space to record your verdict. The indictment in this case does not state the date of the offense the indictment in this case does not state the date of the offense as a material averment or element. Therefore, it is sufficient that the state shows that the offense occurred prior to the filing of the indictment, regardless of the date listed in the indictment. Ladies and gentlemen, by no ruling or comment that the court has made during the progress of the trial has this court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to any other party or the other. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messages, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as a foreperson, dated and returned to be published in open court. Any communication with the court should be made in writing and signed and dated by the foreperson. Ladies and gentlemen, we can only allow 12 persons to deliberate the case, so the bailiffs are instructed to keep the alternate jurors in a separate room or area. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in the case. Ladies and gentlemen, you will be provided with most of the evidence in this case to go back with you in the jury room. However, the DVDs and thumb drives and things of that nature do not go with you back in the jury room. If at any point in time you need to see any videos, then you are to let the bailiffs know. You would come back into the courtroom and it would then be played for you at that time. Some documents were only admitted for record purposes only, and those do not go back with you as well. I am going to provide the jurors, I will provide you all with the stipulations, and I will provide you all with the charge of the court that I just gave you. Okay. Any exceptions to the charge of the court?
Not from the state judge.
Mr. Greenwood?
Linda, just add the verdict form.
Oh, and I also have the verdict form for you guys. Okay. All right, ladies and gentlemen, you can go to deliberation room. They can either go downstairs in jury assembly
I
or.
don't know who they are.
We don't know who they are.
Oh, okay. I'll tell you. All right, alternates are Andrew Lordy and Onike Manzaba.
48